Welcome to the Business SOS podcast. This is Rich Sierra, president of the Florida Small Business Legal Center. This is episode 83 of the Business SOS podcast. Thank you for listening today. We're excited to continue our conversation with John Rizvi. He's a registered patent attorney and the owner of the Patent Professor law firm here in Coral Springs, Florida. Although it's in Coral Springs, he works nationwide. And last week we had a deep conversation on patents. And today we're going to do something a little different. We're going to go a little bit broader. We're going to talk about trademarks, copyrights, maybe touch upon patents again, but also into trade secrets, the difference between those two. And we're going to basically so we cover the whole topic of intellectual property with an expert here today. If this is your first time listening, if you like the show, please follow us in Apple Podcast, Spotify, wherever you see your shows. We're also on iHeartRadio. You can also see this podcast. You can listen to it on our YouTube channel, youtube.com/@RichardSierra. You can actually watch the video of this podcast as well, as well as the other ones that we have in our YouTube channel. We ask you to subscribe as well. Give us a 5-star review as well if you like the show. Hope you do, and this help us help other business owners benefit from this content as well. Let me give you a little background on John's background. We're continuing the conversation with John Rizvi, the patent professor. He's a board-certified patent attorney and one of the foremost experts in intellectual property law. John was among the first attorneys certified by the Florida Bar as a specialist in intellectual property law, and has been practicing for over 2 decades. In addition to managing his legal practice, John has been an adjunct professor at Nova Southeastern University Shepherd Broad Law Center, my alma mater, for over 20 years, teaching intellectual property courses to future legal professionals. He's the author of Patent Protection, a practical guide for inventors, an educational series that explains the nuances of the patenting process. His law firm is also an Inc. 5000 growing company. John's expertise spans U.S. international patent and trademark applications, IP litigation, licensing agreements. He has earned the widespread recognition, including AV rated by Martin de Hubble as well. Today, we're going to focus the distinctions between trademarks, copyrights, and patents, key elements of intellectual property law. If you're a business owner, this is something you want to listen to. John, welcome to the show again.
Yeah, thank you, Rich. Always a pleasure to be here.
So let's start with the first question. What is a trademark?
So a trademark is typically it's a name or could be a logo. It can also be a sound. It can be color. Basically anything that identifies the source of a good or service. So the law protects that source identifier so that business owners can capitalize on the goodwill they have with their customers.
And how does someone what is the process of obtaining a trademark?
So the most important first step is to make sure that the trademark you're trying to get is not already trademarked by another business. So a lot of business owners can do some of that initial research themselves, just going on Google, going online, making sure that the name that they're considering to protect is unique. A good shortcut is to do a search for the domain name. And usually domain names, as you know, are not really expensive to get, like $9 a year, and you can reserve it. So the first step is probably to start with that and see if anybody already has the domain name protected. If the domain name's gone, then you are somewhat limited if that's going to be your business name, because you're not going to be able to get the website. So finding the name is really the first obstacle for a lot of businesses.
Yeah. Also, we talked about logos as well.
So, when I say trademark, most people think of the name, but the trademark can also be graphics. And there's a lot of businesses, Nike's an example, where consumers will just see that check mark looking swish thing, and you don't even have to have any words to identify the company. So if it's not just the name of your brand, but you have a particular graphic that your customers have associated with your product or your company, you want to protect that as well.
Yeah. How important is to do that trademark search?
It's critical. I would say indispensable. You cannot skip that step, because everything you put, every marketing dollar that you put into advertising or marketing your product or your company, it all can be for nothing if you get a cease and desist letter from a competitor saying, hey, you're violating our rights. So you have to start with a professional trademark search. Well, first start with your own search. If it clears that, if you're not able to find anything close, or if you find a few things and you want to know if they're too close to your idea, then speak to a trademark attorney, get an opinion on whether you will, the likelihood of success of getting that trademark granted.
And what is a professional trademark search? What does that entail?
So it's a search of the federal trademark database of every existing trademark that's either abandoned or expired or currently in force. And you'll have what you want is a trademark attorney that reviews for the closest trademarks that they feel could possibly be of concern, and then provides you with an opinion, hopefully a green light that you can proceed. But if it's a red light, it may be devastating. But think of it this way, it's actually a really good thing to find out the early stages of your business. Imagine if you didn't find out and you started and you launched, and now you've got all this expense on a brand that you now have to change.
And it has happened.
It's happened. A lot of well-known companies have had to change their brand after a lawsuit forced them to change brands midway through their company.
A common question that I get sometimes is that I have this business name, and I got a letter from a company in California that has the same name. They have a trademark. Can I still use it?
And that's a common question. And I wish there was a straight answer, because there's different types of trademarks. There are state trademarks, and they don't provide any federal protection. So if the company that's sending the cease and desist letters in California, you're in Florida, the first thing to look into is, do they have a federal trademark? And if all they have is a state trademark and they do not have sales already in your state, then you very well could ignore the cease and desist letter, because they do not have rights to stop your use. But why I say it's a difficult question, because there is a type of trademark legal rights that are known as common law trademarks, and those are in force even if the company never files for a federal trademark. And you get common law rights by use. So if they haven't filed, but they are selling goods or services in your geographic area, this other company may have rights to that name if they've started sales before you, even if they don't have a filing. So that's something important to consider.
If they have, in this particular example, if the company in California has a federal trademark, how would that apply?
Yeah, so if they have a federal trademark, then immediately upon their filing, and there's two types of filing, there's an intent to use, and then there's a use in commerce. So regardless of whether they file an intent to use sometime in the future, or if they're claiming that they're using it currently, the instant they file, they have nationwide first rights to that brand. And even if doesn't matter if they're in California, they have nationwide rights, even if they've never sold a single service or product in Florida or anywhere else, and they've just are based in California and maybe have a few sales outside to another state. They can prevent you from selling anywhere else in the country.
So that's a very important point. I want to emphasize that to our audience, that say you have a business, you have this idea, you open your business, you invest in branding, you have your logo, you have your sign, you start selling, you get a cease and desist letter from another state. They do have erased your trademark. They can prevent you from using that mark. And you have to completely rebrand and take all those signs down.
Absolutely.
And also in this particular case example that we're giving is that if you ignore the cease and desist letter, then they can actually sue you in federal court.
Yep, they can. And the basis then would not just be lost profits, but they could also sue for punitive damages, especially if they've sent you the cease and desist letter, and then you look at it, you still continue to sell your product, and a court can award punitive damages, which is basically punitive is punishment, and a judge can triple attorney
The
fees
damages.
and lost profits and treble damages as well.
So the bottom line is very expensive to ignore a cease and desist letter. If you receive a cease and desist letter, as I've said in prior podcasts, one of the mistakes that people make is ignore them. Don't ignore them. If you receive a letter, you got to call an attorney immediately. Just do not ignore the letter. And also, in my opinion, do not negotiate directly with the attorney. Get an attorney to handle that for you. That's one of the mistakes in my book, which I didn't mention, Business SOS. The common legal mistakes business owners make and how to avoid them. You're going to get it in Amazon, Barnes & Noble. It's available in local bookstore as well. Has 8 common mistakes. It's one of them. Read it. What is the process of obtaining a trademark?
So, typically after you do the search, you'll receive, and I recommend start with your own search for a trademark, but then have an attorney confirm. Sometimes you don't need that. Sometimes your own search, you find your identical brand already in use, then you move on and you continue searching till you find something that's available. Check to see if the domain name's available. If it passes both of those, now it's time to get professional advice and get an okay from an attorney. Once you get a green light, then they'll start the process of filing the trademark. If you're already selling product, then they would file a use in commerce application. And with the trademark application, you have to provide proof of use. So if you're not using it and your business is not operating yet, but you have an intent to use this name, the good news is that's enough to get trademark rights. You file an intent to use application.
And I believe the intent to use is for a year.
There's no set period. You file an intent to use, and typically if it is a year, but I say there's no set period because there's extensions available for 6 months at a time after that. And after a certain number of extensions, then the first few, they don't ask you why, but after some point they're like, okay, now you provide us with, it can't just
proof of use.
Proof of use,
yes,
or a really good reason why you don't have proof of use, and the trademark office would give you an extension. The whole basis of this is that trademarks are based on usage, and it's based on protecting businesses that are conducting business. They're different than domain names, and that confuses a lot of business owners because for years they've gotten used to the domain name market where you can buy and sell domain names and you don't necessarily have to do anything with them. The trademark office does not want their federal database of trademarks to be filled with like dead wood, so to speak, of businesses that are not operating, but yet preventing others from using a certain name. So trademarks are on a use it or lose it basis. If you're not actually conducting business, apart from that initial period where you have a little bit of a grace period, eventually you have to start selling goods or services or you'll lose trademark rights. And that's not the case with domain names, which confuses people. You have an internet domain name or a website name, you could keep it 20 years and never sell a single product and resell the domain 20 years later. Trademarks don't work that way. You have to start selling products. The
trademark has to be in continuous use in order to be active.
Exactly.
Okay. That's very important. Now, people have the misconception that they should buy a trademark and just do nothing with it.
Right. And in another, speaking of misconceptions, there's the trademark for Coca-Cola is over 100 years old. So trademarks, don't have this limited period. We spoke about patents in the past being limited to 20 years, utility patents. Trademarks can go on forever, but misconception is that all you have to do is continue using the trademark. Yes, that's required, but that's not enough. After 5 years, you have to file proof of use. And then after the initial 5-year period, after that, it's once every 10 years. You have to continue proving that you're using. So it's not enough to just use the mark in commerce. You have to submit documentation to the trademark office proving that you're still using it. Those dates are critical as well, which is another reason to have a trademark attorney involved, because 10 years later, who's going to docket their calendar for 10 years in the future.
Yeah.
If you have a law firm, the law firm takes on that responsibility.
Yeah, I think it's important also to the maintenance of the trademark is key, as you mentioned before, because people apply for their trademarks and then they forget about them. They don't do the 5 year, notice,
Right.
and then in the 8th or 9th year they don't file their affidavits, and then they lose the trademark. So then they realize that I didn't get a notice. So it's important when they look at a law firm, that law firm specializes in doing this type of work, because the law firm does it sporadically. That attorney may not be around 5 years later, may
Right.
change practice areas. And then, yes, I have a trademark, and then the attorney gets the email, but he's no longer practicing, or it goes nowhere, and you as the business owner don't get the notice.
Right.
And then you might end up losing your mark. So by having a law firm that specializes in this type of work, the law firm will docket that all the maintenance requirements for the USPTO, and they're really routine. They're nothing complicated, but they're important.
Right.
Because they're not filed, you can lose your trademark, and then you spend 5-10 years building this business along with your brand. You're about to sell that business. Then when your due diligence process comes in, can we look at your trademarks? Somebody goes in, looks at USPTO. This was abandoned 5 years ago.
Right.
Your value of your business is going to decrease dramatically.
Yeah.
Because you went from a registered trademark to a common law trademark. And that really can change things significantly for simply not filing a simple piece of paper.
Exactly. And that's a best case scenario, is that all that's happened is your trademarks become abandoned. But if somebody else has filed, once a trademark is abandoned, it's now open for use for anyone. So if someone else files during the abandonment period, then not only have you lost it, but you can't get it back. You can't, even if you're willing to start the process over, pay another attorney, you're now out of luck.
Yes.
Someone else owns the brand that you built and started, and 5-10 years later you let it go, and now that brand's available to a competitor, and all of your customers, your consumers, they're going to be confused in this other business, especially if in the same business as you. They're now getting all the goodwill from your prior sales.
Yeah, I mean that is critical. Let's talk about a little bit about trade secrets. This is not a topic that people talk about. What is a trade secret in relation to, I guess, compared to a patent? Why would somebody want to do a trade secret versus a patent?
Yeah, great question. The easiest way to understand trade secrets, and I mentioned I teach at Nova to law students, and we have the legal doctrines that I teach, like patent law, trademark law, copyright law. And trade secret falls outside of those three areas and is completely different, because there's no formal filing of a trade secret. There's no trade secret office like you have the patent office, the trademark office, the copyright office. There is no such thing as a trade secret office. So businesses a lot of times are looking for some kind of formal application process and approval process. None of that exists. And it's so funny when you advise clients and even to law students, when you tell them how you protect a trade secret, it seems it's so intuitive. They're like, well, why is this? No wonder it's not taught typically. The way you protect a trade secret is to keep something secret. And that's the simplest way.
Okay.
Now, why is it even an area of law? Why are we even talking about it? Because keeping it a secret is not enough in order for a court to enforce trade secret protection. So if it's secret, like if it makes it to court, basically that means the secret's been out and somebody else is
utilizing
it. Yeah. So you have to show that what steps have you taken to keep it a secret. You have to prove that in court. First of all, you have to show that it's not common business knowledge or not common knowledge that's widely available, that there's something unique about that information. You've taken steps, and then there typically has to be some bad intent or activity by the person that's stealing it. If somebody comes up with the information completely on their own and they haven't stolen the trade secret from you, or done anything that would be considered wrongdoing, then there's nothing you can do. If they properly reverse engineer your product, then they haven't done anything wrong. And I'm going to address your next question. It's brilliant. Is why should somebody proceed with a trade secret as opposed to a patent, and how do you choose? I'll use the example of a Rubik's cube, because as I'm an engineer before I became a lawyer, and one of the things that we all would do, typically the engineering students, is take a screwdriver to the Rubik's cube, break it apart, and then figure out how this thing works, the inside mechanism. So if the Rubik's cube had just relied on their trade secret, it's only a secret until somebody reverse engineers it. So that would not be a good way to keep that mechanism a secret, because if you're selling the product, all a competitor has to do is buy the product and take it apart, and the secret's out. They know how you do it. So what you do is you file for a patent, and now even if they do take it apart and they know how to duplicate what you've done, they're out of luck. So both have pros and cons. The plus of the trade secret is that there is no formal expiration date of a trade secret. If you can keep it confidential for 200, 300 years, it's a trade secret for 200-300 years. Patents are only good for 20 years. So there's that conflict. And it's also a conflict because if you file for a patent is a public document. You're essentially revealing the secret to the world, but the patent monopoly is going to protect you.
Two questions that I had. From a business owner perspective, would a customer list be considered a trade secret?
Yes, absolutely. Your customer list is typically not common knowledge. It's not something that is widely known. You have to take some steps to protect it, and that's why you have a lot of companies have new employees sign employment agreements that have clauses specifically addressing trade secrets and confidentiality. They're under an agreement to keep that information confidential.
They cannot take the customer list, copy it, and then open a similar business, for example. I've seen some of those losses myself. I want to talk about copyrights a little bit as well. Trade secret. I think an example of trade secret is Coca-Cola formula.
It's probably one of the most famous trade secrets that's there. And speaking about like the steps that the companies have taken, they have a incredibly rigorous amount of protection. In fact, at any one time, no two people at the company know the entire formula for Coca-Cola. They even have part of their bylaws for their corporation that the two people that know the formula, different parts, are never permitted to fly on the same plane at the same time. So these are like incredible measures that they've taken to protect the actual formula. And that's why it's something that's now over 100 years old and it's still protected. And going back to your question of patenting versus getting a trade secret, had they only relied on patent protection 20 years after Coca-Cola was developed and patented, it would now be part of the public domain and anybody would have access to the formula. So in that case, maintaining it as a trade secret has been beneficial because it's now, as long as they can continue keeping it confidential and a trade secret, the protection will continue.
Have you been to the Coke Museum in Atlanta?
I haven't.
You gotta go there.
It's on my bucket list.
It's actually, especially I saw it from a business perspective. You'll see it from a different business patent perspective as well. What impressed me about it is that, the vision of the founder, that he really created one of the first distribution systems, and you see the actual documents there. In terms of, they basically said, we'll give you the formula, and then the distributors basically distribute it, and he basically charged a fee for the royalties for utilizing the formula, but he gave them the actual final product. So that's the way he developed, and I'm doing this out of memory, how he developed the first, not franchise, but the first really distribution systems for the product. which he didn't have the money to go ahead and sell it himself, but he created all these distributors, independent distributors, by allowing the product to be sold.
And a lot of foresight to do that
Yeah.
in a way that keeps the formula confidential.
Yeah, and you see some of the contracts there printed, so you got to see that.
Wow.
You certainly have a lot of fun, and it's really very insightful to see that. Let's talk briefly about copyrights as well. Tell me, what is a copyright?
So, and just like a quick review, patents protect ideas, typically inventions, business processes, methods. Trademarks protect the branding, and then it raises the question: so, what does a copyright protect? You can think of everything else that businesses typically produce, like you have written material, email campaigns, website, visual stuff, graphics,
Books, for example.
Books.
Yeah.
So written material is probably the most common, but films, especially now with so many companies putting out social media content and video format, all of those videos are potentially copyrightable subject matter. So companies really need to take the time to make sure that their intellectual property is protected and not overlook copyrights, because I've spoken to a lot of business owners that would say, well, our products, we're selling a product that's commonly known and we have nothing unique there, and our brand is protected with a trademark. So intellectual property wise, we're done. And I would ask if their website is protected. They haven't like, what do you mean? How do you protect a website? Well, copyright will protect a website, the look and feel, the way the different components are, and the graphics. If you have certain backgrounds or backdrops, or in fact, even if you have a unique Zoom backdrop going to the digital arena, you can get that copyrighted, because if you've developed it and you think it's unique and gives you a business advantage, why not have exclusive rights to it and prevent others from doing the same thing? Pictures, photography is protectable.
And you mentioned pictures, photography, and one of the common things that I see here is that people with good intentions download pictures from the web for their website, and they just stay as royalty-free pictures. They just use it, put it in the web, or their web designer does it, and they like, I don't know, I just had a designer do it for me. Then they get a cease and desist letter from some company and asking for $10,000.
Right.
Some of those companies are doing it simply as a mills, but some of them are legit. So what would I advise business owners in terms of if they're going to develop a website or any type of brochure? How they should get their pictures?
Yeah, so typically and business owners are not going to like this advice, but you should pay for the pictures.
Yes.
You can license rights. And yes, it's an added expense, but it's so small in comparison to the risk of a suit. And the old method before the digital world, it was really time consuming and messy to get permission. So it's easy to say, okay, if you want to use an image, get permission from the author. And like, it's so hard to track down the author and write to them and get permission. But there are stock photography websites now that make it easy. Some of them even have, if you do a lot of content, you can buy a monthly or annual subscription, and you don't even pay per item. You have just an unlimited use of whatever you want to use there. There's also copyright. There are copyright-free locations where you can get images, but I don't want to advise anybody to try to figure those out on their own, because there's a lot of scam companies that have names so similar to Wiki Commons, for example, or where you can get royalty-free images, that you're liable to make a mistake and take an image from somewhere that's not a free, royalty-free image, and it's actually copyrighted, and then you can find yourself subject of a cease and desist letter. And a lot of those letters are not just asking you, the way it sounds, cease and desist, like basically stop, and you can say, okay, I'll stop, I'll take it down. Sometimes that's not enough, because they want damages for the use that you've already had.
Yeah. And I see that. I can give you a lot of examples. Actually, an example that it's probably like 10 years ago, and I remember that somebody had a daycare center. So they thought it was a good idea to have some images of Disney World and the Disney characters at their daycare. So of course they got a cease and desist letter from the law firm, and their law firms that their only job is to police trademarks and copyrights. That's all they do nationwide. And they have already a system, a process that cease and desist letter first with a pro-settlement agreement. You ignore it, you're going to get a guaranteed lawsuit, you know? So when I saw that, I told them, oh, you got to take this down like immediately. We were able to resolve it for very few dollars, but we were able to resolve it. And when I see those letters and the client really is at fault here, I said, we just have to be nice. Sometimes, asking for forgiveness works better than being, belligerent, because that's going to make it matters worse. Sometimes say, you know what, I was wrong. We'll take it down. What can I do?
Right.
And sometimes they said, okay, that's fine. You acknowledge it, and we didn't know. It's in the worst case scenario is that when you hire someone to do that art for you, and that person basically breaches somebody else's copyright, puts it in your business, you can still be liable for that. You're utilizing it. And that's the worst case scenario, because the business owner does not know.
Right.
They should have known, but they don't know that. And then my advice, and I think your advice as well, listen, just buy the pictures, get the license. The pictures are negligible. Sometimes it costs like $12 or $5 to get a licensed picture. And then just save the license, save the receipt, just to make sure that 5 years later you don't get a letter from someone, because that happens. There are unfortunately some outfits out there that are sending letters to extort some business owners. And I'm not going to mention names, but that's all they do. And some pictures that you cannot even really track the owner. So just the best case scenario, just use it, and also understand what license you have. An example is Constant Contact that I use for my email marketing. They have you want to have pictures. You can purchase a picture through, I think it's Canvas or whatever system they use, but you can only use it within the Constant Contact environment. You cannot use that picture anywhere else, and it's only saved within that platform.
Right.
So
I wasn't aware of that.
Yes. So understand when you're downloading a picture, what limitations you have as to the license of that picture. Don't go ahead and start taking a screenshot and use it for everything else. Because it's $5 can turn into $5,000 very easily by not understanding the limitations.
Right.
So it's just kind of a word of advice there. So I think we cover quite a bit of topic. We cover trademark, copyrights, trade secrets, and in the last episode we cover patent law as well. John, how can people find you?
So our website is The Patent Professor. The name of my firm is The Patent Professor, and I'm actually adjunct professor of patent, trademark, and copyright law. That's our handle on social media as well. So anywhere, TikTok, Facebook, Instagram, LinkedIn, just type in The Patent Professor and you'll find us, or go to our website, thepatentprofessor.com. And
your law firm provides all these services, patent, trademark, copyrights, trade secret, licensing.
Everything related to intellectual property.
Okay. You handle that, and you work nationwide as well.
Exactly.
Right. And they can actually, I saw your website, they can actually make an appointment right there through your website.
They can, on our website, and there's no cost for the initial consultation.
That is great. In our show notes, we're going to have a link to your website as well. John, thank you very much for coming. This has been very insightful. I learned a great deal today. Within patent, trademarks, again, we got a refresher on intellectual property as well, and trademarks and copyrights. But hope you come back again.
I hope to. It's always a pleasure to be here.
This is exciting. Thank you again for coming. And if you have any questions about today's topic, send me an email at richsierra.com. If you want to learn more about our legal services, my website is floridasmallbusinesslegalcenter.com. We're in Facebook at FSB Legal. If you want to watch the video of this podcast, we're on youtube.com/@RichardSierra. We're on Instagram at FSB Legal. You can call us at 866-842-5202. Also, Business SOS, ACOMA Legal Mistakes. business owners make and how to avoid them. It's available on Amazon, Barnes & Noble. You can ask for your local bookstores as well. And if you like the podcast, follow the show. We're on Apple Podcasts, Spotify, wherever you listen to your shows. And also, if you will see our YouTube channel, subscribe as well and share with your friends. Until next week, this is Rich Sierra with the Florida Small Business Legal Center. Remember that my goal is to help you succeed.